today's webinar. This is the fourth and final webinar in our Advertising, Media and Brands Global Compliance Challenge series, which began last November. Throughout the series, we've covered topics such as managing the cost of living crisis, data and technology, tax, anti-counterfeiting and brand protection, trademark strategies for the digital world, and private prosecutions as an effective tool in brand protection. Last year provided unique challenges for businesses operating across the media, advertising and brands industry. Aside from the impact of the pandemic, we're also seeing challenging and changing landscape due to increasing economic, consumer, regulatory and compliance pressures. And we expect this to continue throughout the year. With increased exposure as a result of these pressures, we've hosted 4 webinars to support the industry in navigating these challenges. My name is Carlton Daniel, and I'm a partner in our IP and technology practice based in London. I'll be hosting today's webinar. Today, we'll be focusing on the rise of ESG and greenwashing, plus some of the workforce challenges the sector is facing, such as DEI, global policies, and immigration. So, without further ado, I'd like to introduce my colleagues who will be covering the topics on today's webinar. John Bloomberg and Anita Lloyd both specialize in environmental, safety, and health issues. They're joined by Nina Driver from our corporate team and Natasha Marek, who sits in the IP team with me. Providing perspectives from both the UK and the US, they will cover greenwashing, compliance with advertising rules on sustainability, product labeling, supply chain monitoring, and conscious consumerism. Lawyers in our labour employment team, Michael Kelly, Bryn Doyle, and Mei Chung, will then discuss some of the workforce challenges such as DEI, global policies, and immigration. So let's jump right into our first topic and hear about challenges on the rise of ESG, greenwashing, and compliance with advertising rules. John, I'll begin with you. What are some of the current trends in ESG in the US?
Thank you, Carlton, and greetings, everybody. I think first, it's important to make clear that most of what we are talking about today is the E part of ESG. And when we think about ESG, it's environmental, social, and governance issues. But as we relate to the topic of greenwashing, we're mostly talking about E, or environmental claims. So when we look at what's going on in the United States, I think the thing I've observed with corporations that I've worked with on these issues is that they're becoming more thoughtful. And part of that is a result of critiques that we've seen on ESG issues, both from the left and the right. From the left, it is the claim of greenwashing that we're going to be talking about today. From the right, it is this, they don't call it greenwashing necessarily, but the concept is similar, that and I guess pejoratively they might call it wokeness on the part of corporations, but it's this notion that there's not much there when corporations are making ESG claims. So I think well-run corporations are looking at this question of what is the true value of an ESG exercise or an ESG program, and making sure that they are confident that they're addressing true corporate issues of value to shareholders. For example, what parts of the ESG program are related to shareholder value, what parts of ESG programs are related to managing corporate risk. And I think there's going to be a continuing dialogue around those issues. The other thing I would point to as a fairly significant trend in the U.S. right now is the U.S. Securities and Exchange Commission's proposed rule on climate reporting. The rule was proposed last spring, generated thousands of comments that we can't spend time on right now, but the comments related to 2 kind of general themes that I'd characterize. One is math, getting the math right, or maths for our friends in the UK, getting the math right in terms of do those the accounting practices that the SEC is proposing, do they line up with other methods of accounting, and are they verifiable? The other is this question of materiality and whether it really is a function of the Securities and Exchange Commission to adopt a rule that requires this level of accounting, and is it truly related to managing shareholder risk or informing shareholders of potential corporate risk? So that is an ongoing thing. Those rules will be finalized, I would expect, at some point in the next year.
Thank you, John. And I think we'll hear from Nina and others shortly that there'll be some synergies there with the UK position for sure. Now, what are some of the pitfalls in ESG implementation and reporting?
Yeah, and given there are many, but given our time restriction, I'm going to highlight one, and it goes back to this question of doing the math properly, particularly in large corporations. There's been a focus for years in the U.S. on carbon reporting, carbon accounting, either voluntarily or as a result of the U.S. Environmental Protection Agency's requirements around greenhouse gas reporting. But my experience is that different elements of a corporation, particularly a large corporation, are keeping track of carbon accounting in different ways, and there are often different divisions within a corporation doing different math. And so I've worked with companies where the accounting for purposes of EPA reporting or other voluntary measures doesn't necessarily line up with the accounting that's being done for perhaps public claims or other public disclosures. And so one significant pitfall, and it relates to this question of making sure that the claims are accurate and verifiable, is that the math lines up, that everybody internally is doing the math around carbon reductions, carbon emissions in the same way, such that you don't create multiple different public disclosures that are at odds with each other. And I think that's a fairly significant pitfall that folks should be aware of.
Thank you, John. I guess there's a whole industry of people who are helping with those mathematical calculations. Yeah. Now, I know about the UK green guides, but apparently there are some US ones too.
Yes, actually, and they've been on the books for years. The U.S. Federal Trade Commission has the obligation of enforcing against unfair or deceptive trade practices and can bring substantial enforcement actions against companies who are alleged to have done things that are misleading in the marketplace, so mostly focused on consumer product claims. And as part of that, the Federal Trade Commission has published in the Code of Federal Regulations a series of rules, even though they call them guidance and say they can depart from them in certain instances, but that are called the Green Guides and have been called Green Guides for years, that establish practices specific to certain. They have general environmental claims and address things like verification of environmental claims and making sure you've got proper qualifications around any environmental claims. And then they get into specifics like claims of ozone protection, claims of carbon emission reduction, energy efficiency claims, or claims of recycled content. And so I would caution anybody who is looking to market a consumer product in the United States to first, if they're going to make claims relating to the green or environmental aspects of their products, to make sure that they look at these green guides and understand what those guides provide, because that's a bit of a safe harbor against Federal Trade Commission enforcement.
Interesting. Thank you, John. Appreciate that. Flipping over the pond to you, Nina. So John's highlighted some of the current trends in ESG in the US. Can you talk about the UK landscape? Are we seeing a similar approach?
Sure, thanks, Carlton. I think what we're really seeing is similar to the US in terms of the different elements of ESG and how they've moved on in the past year. So we're really seeing the E and ESG moving beyond climate change into areas such as biodiversity, supply chain concerns, and deforestation. We're seeing social factors shifting now to focus on issues such as human rights, workers' rights, and well-being across the supply and value chains. And on governance, we're seeing a shift from regulating to ensure transparency through disclosures to more of a focus really on how businesses integrate ESG in their decision-making, their systems and controls, and their governance frameworks. Now, we've also begun to see a recent wave of anti-ESG sentiment that's been building in the US with what's being labelled as anti-ESG legislation that's aimed at deterring or eliminating ESG considerations when investing state funds. That's really politically charged, and here on the other side of the Atlantic, whilst there is still scepticism of ESG ratings, with investors questioning accuracy of data used and different methodologies that are used, shareholders here in the UK have demanded greater transparency in how companies measure their ESG performance, and in turn that's really resulted in a stricter regulation of ESG reporting. I feel that we're now reaching a crossroads where businesses need to work on improving the accuracy and the transparency of their ESG data.
Interesting. So it's both ends, isn't it? The kind of shareholder activism on the one hand, and the increased almost the kind of reaction to the ESG. Interesting. So when you're evaluating those risks, Nina, what does effective governance look like for a company board?
I think that there needs to be visibility really across a company's governance structure to make sure that there's procedural avenues to review each of those threads, each of the E, S and G areas of exposure. And within that ESG strategy, each business will have its own risk tolerance together with a response plan, including effective routes of maximum escalation for risks that do materialise. And when evaluating ESG risk, communication is key. So the communication will work and be natural if the right management structure is in place within a business. So boards need to consider how information flows to any subject experts and to other managers, and really how it flows back up to the board. So strong communication flow both ways is very important, and boards need to engage with their management teams to ensure there is that bi-directional conversation on ESG issues. I think that annual reporting is not just a one-off event, and boards can influence the culture and tone that a company's taking in addressing ESG topics, and by asking the right questions, such as, are we really thinking of these ESG topics on an appropriate basis? How are we regularly reviewing them to make sure that new issues haven't bubbled up? Or are there any new topics in the industry or the marketplace that might trickle over at some point? Now, moving on to greenwashing, there is a growing assumption that if a company doesn't disclose or discuss a certain issue, that it's really hiding something or it's not addressing that issue appropriately. But really, the issue might not be material for that company. So businesses should disclose and discuss material topics, but acknowledge if an issue is not being addressed. Why is it not being addressed? Why is it not relevant? And why is it not a focus for the company?
So silence is no longer an option. You've got to, yeah, okay, interesting. And so you've listed a lot of things there that companies kind of need to think about and to take account of going forward. What are some of the main things that you expect boards to be focusing on in the year ahead?
I think that there's some interesting themes really that have come out of last year, Carlton, that are going into this year. So climate transition plans are set to become more common, and those plans will detail how workers will be supported and the need for upskilling and reskilling to be addressed. We've seen last year an increasing number of companies setting climate targets, including net zero emission targets, but questions remain as to whether those targets are achievable. So in 2023, this year, we'll be watching which companies upped their climate target game in the face of what we expect to be increasing pressure from institutional investors who have their own portfolio net zero targets to meet. Other threads of ESG coming through into this year will be businesses looking at their environmental footprint through the lens of biodiversity. We're seeing new standards and guidance continue to evolve, and many businesses might wish to be proactive by engaging with those voluntary initiatives. And the last two things really we're going to see this year is that the equity in DE&I will take on more significance for businesses. Here in the UK, due to what the increased cost of living means for businesses, staff, and those working across its value chain. And lastly, supply chain management will continue to be a key focus. I think with the introduction of blockchain technology for supply chain transparency and traceability, where perhaps successful experiments in that field could herald the beginning of a sea change in supply chain management.
Excellent. That's really valuable insight, Nina. Thank you. Natasha, if I can turn to you. So we've got obviously the Advertising Standards Authority, the ASA, in the UK. Does it have any rules which regulate environmental claims?
Yes, so the UK's main codes of conduct for controlling advertising content, they're known as the CAP and the BCAP codes, and they're enforced by the ASA. There are general rules in these codes about marketing communications not being materially misleading, and then there are also specific rules in the codes in relation to making green claims for products or services. One of the key rules in the codes is that advertisers must ensure that the meaning of an environmental claim is clear. So, for example, the ASA investigated an ad for dairy-free milk alternatives, which included the claim "good for the planet." And it ruled that the ad breached the code, as it was not clear whether the claim should be understood in isolation, i.e. this product is good for the planet, or as a comparison with equivalent dairy products, i.e. this product is better for the planet than others. And because of this ambiguity in meaning, the ASA found that the ad was in breach of the code. Another thing to note is that claims that are unqualified can be misleading if they omit significant information. So there was another interesting ruling from the ASA, and that was in relation to a claim made by a bank that it was helping to plant 2 million trees. The ASA held that whilst this statement was accurate in isolation, the claim was in fact misleading, as the bank was at the same time embarking upon environmentally damaging causes and they had neglected to include this information. The ASA's rules also state that absolute claims must be supported by a high level of substantiation, and the default position being that those claims should be backed up by robust evidence. So that's also one of the general rules under the codes. It doesn't only apply to green claims, but it's of course an important one. And advertisers should bear in mind that absolute claims, so that's something like, the greenest or the most environmentally friendly, they're more prone to hyperbole, and therefore they will be very difficult to substantiate to the requisite high standard. On the other hand, comparative claims, so ones such as greener or friendlier, they tend to be more easily justified, but it still needs to be important that it's still important that the ad makes it clear exactly what the product is being compared against. Another key rule is that claims must also not mislead consumers about a product's environmental benefit. So one example the ASA gives is that the ad should not highlight the absence of an environmentally damaging ingredient if in fact that ingredient is not usually found in competing products. And then finally, claims must be based on the full life cycle of the product unless the ad states otherwise. And claims that are based on only part of a product's life cycle must not mislead consumers about the product's total environmental impact. So the ASA investigated an ad for an electric scooter by Tier, where the advertiser included a claim be environmentally friendly, and the ASA ruled that that claim was misleading. The advertiser had argued that it was implicitly a comparative claim and that the scooter had less of a negative impact on the environment than alternative modes of transport. But the ASA disagreed with this, and they concluded that the claim was likely to be understood as suggesting that the scooter caused no environmental damage over its full lifetime, which was not something the advertiser could demonstrate. So that's just a kind of quick overview of the key ones, but there are others too. And another thing I think to be mindful of is that environmental claims remain under close scrutiny from the UK, the main UK regulators, and the ASA has said that it's in the process of reviewing its rules. So it may very well be that there is going to be kind of further guidance or further rules that are issued in due course.
Thanks, Natasha. And I think those are some really, really good examples in times gone by. You might have expected the regulator to sort of consider, good for the planet advertising puffery, and it seems it's now much stricter, and it's not just kind of charities or whatever that were the ones historically who got in trouble for this sort of thing. It's now large international financial institutions and banks who are being hauled up by the regulators. Interesting. Unfairly, perhaps, the ASA is sometimes labelled a toothless regulator. What can they do if people are falling foul of the rules?
So if the ASA finds that the codes have been breached, they can impose a number of sanctions, and that includes publication of upheld complaints on its website. It can arrange for advertisers to be refused advertising space, and it can even impose pre-vetting requirements on advertisers' ads. As decisions of the ASA are published on the ASA's website, companies that are found to be in breach of the rules can also face adverse publicity and brand damage. And we find that often where well-known brands are involved, the ASA's rulings will attract adverse media coverage, so you'll see it in the kind of mainstream press. The ASA does not actually have any power to fine or imprison. However, if it can refer advertisers who persistently breach the codes to trading standards or to the Competition and Markets Authority. And it's those statutory regulators that do have the ultimate power to take court action and levy fines. But in practice, the usual route to handle advertising regulation is going to be via the ASA.
Yeah, and I suppose with no power to fine, no real risk of imprisonment. If I were a cynic, I might say that an errant advertiser might take their chances with the ASA rather than if they want to operate at the edge of the law, rather than complying with increasingly strict rules that you've outlined. Interesting. Natasha, thank you. If I can come to you, Anita, sort of looking beyond advertising regulation, how is greenwashing more generally regulated? Maybe not just in the UK, but if you can talk a bit about Europe as well. Is there special legislation on green claims along the lines of what we were hearing about earlier, or product labels?
It's I think where we are at the moment is two words. I think evolving and fragmented are probably quite good words. So UK first, we don't have any specific legislation on greenwashing in the UK. What we have got, in addition to what Natasha's already outlined, which is a very big part of it, the sort of advertising standards regime, we have the Competition and Markets Authority's Green Claims Code. Now that's guidance, and it's guidance on how that regulator should enforce the pre-existing consumer and business protection legislation from unfair practices, effectively. And a lot of what that green code says is very similar to what the advertising rules say. So those same themes that Natasha's mentioned. But the CMA does have potentially more teeth, as we've already mentioned. So in the UK, no specific legislation, but guidance. And then in the EU, there's quite a few different proposals at EU level. So again, focusing on the Unfair Commercial Practices Directive, there are some specific amendments proposed to that to effectively bolster the way that applies to green claims. So it already applies to green claims in the way that it applies to any other kind of product claims, but it's bolstering it and making it more overt and express in the way that it can cover environmental claims. And in parallel, the EU is also developing some legislation on substantiating green claims. So, what is the evidence that would be needed to substantiate particular green claims? So, but it's all evolving. And then what we've also got is member state individual activity, which is potentially going off at tangents and going beyond it. And I think France is a really good example of where they've taken a lead. And for example, France has very recently imposed effectively outright bans on claims about products as being biodegradable or being environmentally friendly and similar regimes. So I think until we get that consistency at EU level, we will continue to see this more fragmented approach across the EU, but it's building.
I think the point you make about evolving is an excellent one. I heard about the France thing just very recently, and it's sent a number of people into a bit of a spin. So it's something that one's definitely got to keep an eye on. And now, liability for greenwashing, how does that most often arise? What types of liability are most prevalent?
Yeah, so I think one of the main ones so far is the advertising sanctions regimes that Natasha's talked about. But the CMA in the UK are very actively investigating various different sectors of the economy. So, someone like the CMA can respond to complaints from consumers and from other bodies and from the advertising regulators potentially. But they're also initiating their own investigations. And the CMA's looked at fashion, and last week they announced that they were going to be looking into, I think they called them household essentials. So food, drinks, toiletries. They're going to be specifically looking at how green claims are made about those products. And, we can expect there to be potentially some regulatory action coming out of that. And they do have powers to impose fines, as do the trading standards local bodies as well. So, we haven't seen that yet in the UK. We haven't seen, but I think it's on the horizon. I think we will be seeing it soon. And I also saw something recently actually about the Financial Conduct Authority saying that they might start to impose sanctions and fines on companies who, in their financial reporting, are making unsubstantiated green claims. So, there's different regulators coming into the game. But I think the other type of liability is perhaps that softer liability, that reputational damage that Natasha alluded to as well, because it is very powerful. And yes, the Advertising Standards Agency can't fine people, but I think those statements on their websites and the banning of claims gets pretty widely reported, certainly in the environmental press that I read. So I think we're seeing a bit of a building, and I think it'll be interesting to look to see where the CMA's first sort of flagship fine or action comes. And I don't think it'll be very long to wait for that.
Thank you, Anita. Nowhere to hide with all the regulators after you. And so we heard earlier about the guidance, the CMA guidance on green claims. And of course, the Advertising Standards Authority doesn't regulate labelling, but the CMA and trading standards do. So in terms of labelling, are there any mandatory green labelling schemes or anything coming down the track?
Yeah, again, lots of different things going on at different levels. So EU-wide, we've got some labelling under the Single-Use Plastics Directive already, which is requiring certain products that contain plastic to be labelled as such. We've also got proposals at EU level for packaging labelling, but these are very early stage proposals, and we don't exactly know what those will look like yet, but those will be about recycling, recyclability, and waste management aspects. We've had a regime at EU level for some time, which has been voluntary on, again, packaging labelling regarding what the packaging's made of. But Italy has just made that mandatory as of the 1st of January 2023. So we've got Italy with the packaging composition gone live just now. We've also, again, France is another example. France comes up time and again with these sorts of things. France have got their own labelling regime. Again, they have this special Tri-Man logo, which is about recycling and other statements that need to be on certain types of products about recycling. And then in the UK, we have got a proposal that the labelling, which you'll see on a voluntary basis quite extensively at the moment. So the little swoosh, the little arrow swoosh symbol, that's going to be mandatory in the UK on packaging from 2026 is what they're saying at the moment. So again, various regimes in place and a lot more coming down the track.
Interesting. Thank you, Anita. Thank you. So we're going to do some camera swapping, I think, now. John, Nina, Natasha, Anita, thank you for those insights on greenwashing. If we flip now to our workforce challenges in our employment and immigration team. So obviously there's huge challenges in this sector. Michael and Bryn, if I can start with asking you to provide an update. And Michael, if I begin with you, please. So in your view, have clients in the US seen a real impact on employment recruitment and retention when they invest in ESG?
That's a great question, Carlton. My experience with clients has been that investment in ESG is what you might call table stakes for entry-level recruiting of college graduates in a field that is full of potential employers where new graduates are delving into the internet and looking at everybody's websites and doing Google research. Nobody wants to go back to their friends in the cafeteria or the dorm and say, I'm going to work for, pick your favorite company that just got headlined for being accused of greenwashing. So definitely seeing it have an impact at entry-level recruiting, but don't see it having an impact at retention and recruiting at mid-level and senior levels in companies. You might attribute that to a certain degree of cynicism that comes with a longer career, but whatever it is, we're not seeing it have the same impact there that we're seeing DEI initiatives have. We do see a lot of clients where a failure to make meaningful progress on DEI is costing them in recruiting at the more senior levels in their companies, and it's impacting retention. Imagine a mid-level person looking around trying to figure out, am I going to advance in this company or not? And they don't see anybody above them who looks like them, who is of the same gender or gender orientation. And so they start in that context moving around. So I would say, at least in the US employment market right now, tangible efforts in DEI are more important to retention than the ESG. That's something that, as my colleagues who spoke earlier talk about increased government regulation, the regulatory and shareholder implications of ESG will rise. But again, I think people are going to be evaluating, is this a stable company? Will this be a strong company 5 years from now? ESG will be one of many factors, but it's not driving the retention at the mid and high levels in companies.
Interesting. So that fight for talent is really hottest on the ESG topic at the junior level, not at the senior. Okay. And so sort of flashing that forward, what developments do employers have to look forward to in the year ahead?
I think the biggest challenge that many employers are going to face in the US is a rising set of transparency laws around advertising for job positions. California, New York City already have in place now laws that require you to post on any job board the pay range you expect to pay for a position. Challenges there. We all know that sometimes you have to pay more to get somebody into the company than if you're promoting from within, because those people are already invested. But now when they look and they see that somebody who's getting hired into the same job that they have might make a lot more than them, it's going to create some internal issues. It also has some complicated regulatory issues that can arise because with so many positions in the US now being filled remotely, identifying just what jobs will actually be a California or a New York City job is itself a complicated prospect. The blight of employment laws in the United States is, from an employer's perspective, plaintiff lawyers who are chasing around looking for large class action claims they can make, and being able to make claims on behalf of every applicant as opposed to just the handful that actually get the job increases the damages that the plaintiff lawyer might get their hands on. So we think that in the coming year, we expect a number of states to follow California with similar pay transparency laws. And because the United States in employment is more of a quilt than one continuous blanket, employers with multi-state operations are really going to have to look closely at how they comply with posting jobs in the future.
The pay transparency issue is a very interesting one, and I could ask you 100 billion questions about that, but there isn't time. Michael, that's brilliant. Thank you. Let's run to the other side of the pond, back to the UK. Bryn, what are the major challenges to employers in the UK?
Yeah, and thanks, Carlton. And it's actually very similar to my colleagues in the US as well, that we are seeing a drive towards this war on talent and retention of employees. And employees more than ever before are clued up and are happy to do research on their employers. And so it's about trying to win quality, win talent. And the employers who are doing the best in that are the ones who are facing into some of those ESG, DEI challenges that employers face. I think, taking on Michael's point before about ESG in the US and kind of the mid to higher level employees and attracting that level. I think in the UK we're perhaps a little further down the track. It feels to me that mid to high level employees are looking at ESG, and every level is looking at DEI. And I think perhaps our legislation in the UK is, again, a little further down the track in terms of protection on the DEI side, but where we're not quite as far down the track is protection on the ESG side. And so for me, I think the focus will be for legislation, certainly, that we will start to see more legislation that impacts upon people from the ESG side as well, and that's going to have a real impact upon retention, recruitment, and so on. So in terms of challenges, the majority of challenges that we're seeing in the UK are those around retention and recruitment, and a lot of this stems from the post-COVID world. So a lot of this is around actually providing an environment and a culture that we can attract talent and attract people the best people to come and work in our businesses. And so a lot of that challenge at the moment is, for example, around working from home, flexible working, agile working, hybrid working, whatever you want to call it. And there's a challenge at the moment between the more traditional type businesses who perhaps want their employees to be in the office 5 days a week versus those businesses who are perhaps prepared to be a little bit more flexible, and actually particularly in advertising, media, brands businesses, where there is perhaps an expectation of that workforce to be able to be a little bit more flexible than some more traditional areas of industry. That's a real challenge for those businesses. So my advice for clients who are in that space is be as flexible as you can be, because that's how you're going to be able to recruit and retain that talent.
Interesting. Thank you, Bryn. Some real differences in the approach in the UK to the US. Interesting. May, if I can come to you, obviously you're an expert in immigration law. What are the recent challenges that you've seen for employers?
Well, I'll start off with the UK challenges for UK immigration, since I'm a UK immigration lawyer. There's a few issues, of course, we've talked about. Well, first of all, we had Brexit in 2020, and we've had lead up to Brexit, all the EU nationals, a lot of the EU nationals and their family members were leaving the country. And then we had COVID as well, where people were leaving the country to go back home, to work overseas, and to work in different countries where they fancied working, where there's better climate, which leads to a lot of shortage in workers and shortages in skills in the UK, which my colleagues have talked about today. And a lot of employers in the UK have gone to sponsor workers, recruit from overseas, and that also helps them with the DEI initiatives in getting a more diverse workforce as well in the UK. Issues is that one is that the Home Office has seen a rise in sponsor license applications. In order to get someone in the UK, obviously you need the companies need to get licensed first. So has been a lot more applications, which means delays
delays with the process itself. Cost as well is another issue. Sponsorship itself is not cheap. So give you an example, for a single applicant coming from overseas to work in the UK for a 3-year visa, it costs the company about £10,000. I mean, some larger companies might not think it's a lot because recruitment agencies sometimes cost a lot more. But for smaller companies, it is an issue when it comes to recruitment from overseas. And then the worst case is that, you know, you've paid all the fees and you've sponsored them, got the visa, and then the employee decided they don't want to start with you because the employer's offered a higher salary, or they've decided they're going to go to a different employer altogether, and you've lost all the costs and the fees that you've paid already. So vice versa, as well as obviously against the UK, there's the EU side as well. So we've got British nationals in the UK also needs to work in the EU, and you know, with Brexit, it's been a lot more difficult since, and they've realised that they actually need to get work visas for British nationals going to the EU, and processing time for work visas in the EU is much longer than the UK. It's 3 to 6 months in the EU rather than 3 to 6 weeks in the UK. I'm not just trying to sell the UK, but this is how it is, and it's just a lot more planning needs to be done ahead of everything when it comes to, you know, work visas in the EU as well, because there's different laws and different requirements that comes up with different EU countries. So recently I had an individual who had this roadshow project, and they had to work 8 weeks in Germany, 8 weeks in Poland, 8 weeks in Croatia, and 8 weeks in Bulgaria. And it took much longer to get those visas for different countries just to get that individual into the roadshow. So it's a lot of planning ahead for companies in the UK, and I guess in the EU as well. And then we have not just the visa issue when we have business visits as well. If British nationals are visiting the EU, different EU countries will have different requirements and what you can do in that country. So maybe you could do a little bit more in Germany, but in France it might be more restrictive. So you need to get a different immigration law from different jurisdiction in order to make sure you comply with the regulations. And then aside from that as well, another challenge is that obviously with hybrid working, a lot of employees are working in different countries. So employers need to make sure they have the right to work in different countries, and some even work in 2 different countries, or 3 days here and 3 days there. So it's a lot more to think about on the immigration side for employers.
Excellent. So there's a lot for employers to think about there, and it sounds like there's some really serious challenges. Is it going to get any easier in the year ahead?
I mean, the competition for skilled workers and shortages of workers and the cost itself for UK visas is not going to improve. Okay, but UK is moving more digitalized, which means it's going to be much quicker process, and it's going to be less paperwork. And you think you can take that for granted, but it's actually not true with EU countries. A lot of them still require notarized documents, legalized documents, originals being sent to them. So the UK part is much easier already. And I know I'm going to sound like DIT or Home Office trying to sell the UK, but it is true that if you have UK companies in the UK right now and you want to employ, I think the few tips you need to think about is get a license, get a sponsor license if you haven't already got one, because it'll make you much more competitive as an employer for those candidates. Make sure your HR process is in order to make sure you can meet the sponsor's duties if you were to get a license, or making sure that right to work checks are compliant in the UK and overseas where workers are. And the third tip is that you need to make sure your recruitment process is also in order, so that if you have the right candidate, you can make sure they get the visa very quickly and tie them down to the company. So on that note, I'll switch it back to Carlton. That's it from me.
Thank you, May. That's super useful. There aren't any questions at this stage, so I'm going to come back to Bryn. So Bryn, you were talking about the difference between the UK and the US. What are you seeing as a consequence of the rise of DEI awareness in the UK?
Yeah, I think it's a really interesting thing, and we've definitely seen a significant increase in certainly as advisors in investigations. I think it's a consequence of employees being either more aware of their rights or perhaps more empowered to be able to raise complaints or grievances and so on, which as a consequence of which investigations need to be carried out. I also think that employers are perhaps taking those complaints and grievances more seriously, as they should do, and that the employment tribunals, the court system here in the UK, is also recognising that as a financial value, and so therefore are penalising employers for not having a workspace that is fair and equitable. And so I guess what we see as a consequence of the rise of DEI is that we have employees who more than ever before are empowered to raise complaints and raise issues, more than ever before are aware of their rights, and more than ever before are prepared to do so, probably as a consequence of that war on talent, that there is more opportunity in the UK for employees. We've got our close to lowest rates of unemployment that we've ever had, and so there's more choice, and so therefore employees feel a little bit more empowered to be able to raise those complaints, and and that's a good thing, because what it does is it flushes out those employers who are more unscrupulous, and it creates an environment that is more inclusive. And for me, as an advisor for businesses here in the UK, I then flip that on its head and say, okay, let's use this as a positive. So let's embrace our DEI initiatives. Let's embrace our equality, and let's go and let's hunt that talent down, and let's say to them, you want to come and work for us because you know what, it's a great place to work, it's a fantastic environment, and it's a respectful environment. And I think that's rather than seeing it as a negative, I kind of try and flip it and see it as a positive.
I like that. Put a positive spin on it. Absolutely.
Yeah.
I like that a lot. Thank you, Bryn. Coming back full circle to end with you, Michael. I know there are some FTC rules barring non-competition agreements. Can you just talk a bit about that?
Yeah, absolutely. The Federal Trade Commission decided that they wanted to wake us all up and get us rolling for the new year by issuing a proposed rule. So it's not something that's gone into effect yet. They're in the public comment stage in our administrative law process right now. But what the rule would do, for those of you who are familiar with the state of California, which largely bars non-competition agreements and restrictive covenants, they're purporting to make that a national standard. Excuse me. That's going to have a big impact on this industry in particular, because it's going to mean that your employees can walk out the door today and tomorrow go to work for your competitor. And given the breadth of the FTC's regulation, which not only talks about explicit non-competition, but also the functional equivalent of non-competition, you may find yourself unable to stop them from calling their colleagues and actively recruiting out of your team, and also calling your customers and recruiting companies that they had worked for you. The FTC estimates that this is going to help American employees make possibly an additional $300 billion a year. The notion being that companies are going to have to pay more to keep people because they'll have more options, and it will create a more competitive environment. For those who look and try to assess, well, is this something that's actually going to happen? It's important to note that as a regulatory action, it doesn't require congressional approval. So it isn't subject to the nonpartisan gridlock that tends to characterize our government. And to some extent, it's an issue that plays well on both sides of the aisle. The Democrats can champion this as good for employees, and they like to characterize themselves as the party of employees. The Republicans can look at this and say it's getting the courts and the government out of tying employees to their employer. It's helping entrepreneurs. It's helping small businesses that can't compete with the likes of Apple and Google and all of those favorite high-tech nemesis of the Republican Party. So it's definitely something that employers in the United States and multinational employers are going to need to look at. We don't have concepts like gardening leave, and so protecting your goodwill and your assets that you invest in your employees is going to be that much harder, depending on exactly what the final version of this rule looks like. So thanks for asking about that, Carlton. That is something that's going to impact this industry in particular, I think.
Thank you, Michael. That will be of most interest to the audience. So that's great. Thank you. Okay, well, I think that brings things to a close. So thank you all for joining today's webinar, and thank you to our speakers. We hope you found the subject matter interesting and helpful and insightful. I know I certainly have. And although there weren't any questions specifically to the speakers today, do not hesitate to contact any of the speakers on any of the topics they've covered. They love it. So please do feel free to do that. Thank you.